Hello, everyone. Good morning, good afternoon, good evening. This is Link Up Leaders, your direct link to leaders in supply chain and e-commerce. My name is Lisa Kinski. I'm your producer and co-host, and as always, joined by Francois Jeffrey. I almost just called you Jeffrey. Swa. How are you doing?
Good. Can't complain. How about you?
Doing wonderful. It is finally sunny and 70 here in Georgia, and I am
Yes, it is.
pumped.
I'm here for it.
I am so ready for the spring weather. I'm so excited. And I'm even more excited for our guest today. This is actually her second live stream of the day. I don't know how she does it on top of all the other speaking engagements. She was featured on Branded by Women. We have with us today none other than Yael Cabilly. Yael, how are you doing, dear?
Very good. Thank you. Thanks for having me.
You are welcome. So we are here with you today to talk about IP, patents, trademarks, copyrights, exits, all of the legal stuff that I am none the wiser to. So,
and I get asked hundreds of questions about, and I
Absolutely.
am not an attorney, a lawyer, or have any sort of background in this. So a lot of what I'm able to give out is just, what our factories are able to get back to us. And a lot of times just like, yeah, we don't really know. I don't know. Google it.
I'm
very excited to talk about this.
Have
just
you
Google
Googled it?
Yeah.
Getting you a shirt.
Yael, first of all, am I pronouncing your name correctly?
Yeah, 100%. Yael.
Okay.
That's the name.
Yael, if you wouldn't mind telling a little bit about your background and, how you kind of got into the space of IP and IP protections, and your company is Cabilly & Co., right?
Yeah, correct.
Yeah, if you could give us some background on all of that.
Sure. So I went to law school, and then I started working. I started working at an IP firm, a trademark firm, and I stayed there for like 7 years. Then I moved to New York. I went to school again in Colombia. And then when I came back from New York, I started working with Amazon sellers. That was at the end of 2015. It started with one actually who had a Facebook group, and once I helped him, he said, is it okay if I publish it on my group and tell people what you did so that they'll avoid this problem? And I said yes. And then the next day, 20 sellers came to me. And then he decided to do like a webinar like that. Mm-hmm. And there were like 300 people. And the next day, I think about 40 sellers came to me. So I realized there's a big loophole there. Nobody's, fighting for those sellers.
Yeah, there's a need for what you do.
Exactly. So back at that time, there was one lawyer. Still today, we're probably 3-4 lawyers. So I started a firm focusing on IP and e-commerce. And it grew very fast. Today we're 13, I think. Half of the firm does trademark, copyrights, patents, registration, and enforcement. And the second half does suspension, basically, fighting for the sellers who are suspended. We're very known for IP suspensions, but we do all kinds of suspensions today.
And for those that may not be aware, IP stands for intellectual property, correct?
Right. It includes trademarks, copyrights, patents, trade secrets. These are the main four.
Gotcha.
So what are the differences? And it's a silly question because I like to think that I know the differences. But I think a lot of people don't know, what the difference between a trademark and a copyright even is. I mean, I didn't know until about 2 weeks ago when I was listening to you talk about it somewhere else.
Yeah. Well, I think most sellers don't do. I mean, they call me. I was suspended for copyrights, and in my head, I'm like, what was it? A trademark, a patent? What was it really?
I need more.
Yeah. So I'll say a few boring sentences about each of them so that you'll know, and then we'll probably go through each of them in detail. But trademark, I think most sellers know what a trademark is because they need one, at least the private label sellers. So trademark covers a brand, right? Your brand, your name is Link Up Leaders. And you want to protect this brand, so you apply for it on the USPTO. which is the US Patent and Trademark Office, and then you get a protection for that particular brand for specific products or services. In your case, it would be, a service or the webinar, just protecting the brand in relation to webinars or to sourcing. So that's a trademark. A copyright protects text, graphic design, and images, and that's the one most sellers don't know about. They think that if you have if you have a design on your paper plate, you have to protect it to be protected, right? I mean, if you designed a butterfly on your paper plate, then if you didn't protect it, then everybody can use it. That's actually not true. That's one of the biggest mistakes that we see as attorneys. A copyright exists from the moment you created it. So if you've designed this amazing dog on your shirt, this specific dog that you designed is yours. Nobody can steal it from you. Nobody can use it. They can also design a dog, but not the specific one and copy the one that you did without any registration. And that's where we see a lot of suspensions, because sellers, they take what the factory offers, right? I mean, because you do sourcing. If the factory offers, these T-shirts or again, these paper plates with specific design, and they tell you it's our design, you can use it. Sometimes it's true, it's the factory's design, and you're somehow okay. But sometimes it isn't. It's just the design of the previous client, right? So when that happens, the previous client can just file a complaint against you. And I can show you in 5 minutes how to file a copyright complaint. And I guess after an hour, you're done. I mean, your listing's down. You get this horrible notice that says you've been suspended for your listing has been suspended for copyrights. Here's the complainant. Good luck. And so the best thing to know and to remember for copyrights is just not to use anybody else's graphic design, text, and photos. Okay, that's copyrights.
How do they prove that?
It's a good question. They don't.
Of course not.
So that's it. That's the answer. The long answer is that Amazon asks you for a link to yours. So if I have a listing with nice images, and then Lisa stole my images on her listing, so I just put a link to I complete the form, and in the form on the bottom, I just give the link to mine, and I say, here are my images. You can see that my listing was formed a year ago, and Lisa's listing was just formed yesterday. Please remove it. And they remove it. And sometimes, unfortunately, people take advantage of that. And we've seen just crazy stories of, sellers just filing complaints against each other for they're stealing. What they did is they take everything from your listing, they put it on a separate website, they file a complaint using that website and telling Amazon, this is mine, that guy on Amazon stole it. And Amazon removes it, unfortunately. So you have to appeal, and that's what we do. We write an opinion. We show Amazon that it's a false complaint. But there are a lot of false complaints, unfortunately.
So you're guilty till proven innocent here.
I mean, you're surprised.
Not very surprised. No, it's just I guess it's a common issue that doesn't get talked about enough, and I think it gets talked about a good bit, but only amongst a certain group, only amongst those that it has happened to, and immediately they're like, well, what do I do? Where do I go? They feel attacked because it's they weren't expecting this. Hey, I created my listings, I used my own content, the design is my own, and then they just have their listing taken down. So I guess it's something where you don't really think about it until it's too late, and that's why we're trying to accentuate these types of conversations earlier on, and getting that information out there.
100%. I think that if people knew, and that's why I'm trying to kind of spread the word, if people knew what we're going to discuss today and what we've already discussed, I think that 70, maybe 80% of the suspensions they get related to IP would be canceled, wouldn't exist.
Yeah.
That's my feeling, and that's why I'm trying to educate as many sellers as I can. So going back to I drifted away, but there's
it's okay. So we're going to do that the whole time.
That's what I was talking about earlier before the show. I apologize.
No problem. So there's the trademark right that protect the brand. You have the copyrights that protect the photos, graphic designs, and images. And then you have the patent. Now patents there are two different kinds of patents. There's one that everybody knows. I have a patent. The regular patent, it's called a utility patent. It's the one you heard about that protects kind of the technology, right, behind the product. In most cases, Amazon sellers don't register utility patent just because they're super expensive. They take 3 years to get. So although I'm an IP lawyer, it's very rare that Amazon sellers file those. And then there's the second type of patent, the design patent that covers the shape of your product. Okay, so if you have, let me see what I have here to show. That's my son's pacifier. So if you have this product and you want to protect the specific shape, I don't know why it's on my table here.
They're all over the place.
They're all over the place.
Once you have them, there's binkies everywhere.
Yeah. So I usually show my bottle here, but then it's just on all the webinars. So why not talk about that?
We'll go with the pacifier.
So if you have the shape of that particular product and you want to protect it the exact way it is with the holes, zeros, and everything, then you can cover it with the design patent. The nice thing about it is that it's not expensive. It's about like $2,500 roughly to get it in the US. The good thing is also that it's quite fast and that Amazon knows how to enforce it. So you get the design patent. If somebody does the exact same thing, you can just file a complaint and remove the suspend this particular listing that's infringing your rights. The downside, I guess, is that it protects exactly that product. So if you have that, but the holes here, I don't know, there's another hole here and another one here, and it's longer and the shape is a little different, then that's another product, and Amazon or any other platform just won't remove it. So you need to know that and just accept. I mean, you either don't protect or you protect the shape, the specific shape that you have, and if you have new shapes, then you protect the new ones. So I think it's a kind of good solution for sellers today. Of course, if you have a product that's unbelievable and it's very unique and a special technology, and your entire company is around that product, it makes sense to invest in a utility patent. It's broader. It doesn't protect just the shape, but the kind of the claims around that particular product.
Mm-hmm.
What if that product has several pieces to it? Would you have to file a patent on every piece, or is it the product as a whole with the various components?
Usually, I mean, it depends. It's actually a good question. When there are several pieces, we do a strategic decision what we want to protect. Sometimes protecting less is more, right? If I protect this particular design with all the, with the holes here and that, and this particular panda design and everything, then that's what I have. And if somebody changes it a little, then they work around it. So you know what? Maybe I'll protect just this part, and the rest can be anything else. So maybe I'll protect just the holes here. So, you want to protect less so that you'll get a wider protection. So when there are several pieces, we sometimes decide, okay, that one isn't that important. Let's protect this particular one, or we separate it. It really depends on the product, but this is where the protection becomes interesting for boring lawyers.
No, it's interesting even from our perspective too, because in the example that you had used you had shown the patent drawing of like the water bottle this morning on your episode with Seller App, and then you had also mentioned it in your Branded by Women, but the Camelback bottle, I have something very similar, but it's a different brand. It's Contigo, and I'm wondering like, how is this not? I mean, they have like a clip here where you can like use it on a backpack or something, and this has a lock for the straw. But I'm like, how is this not infringing on Camelbacks?
Okay, so I should have my Camelback photo here, but and by the way, I'm trying to change them all the time so that I want to have the same boring examples. So the thing is, as I said, with design patents, it kind of protects exactly what you have. And I'm 100% sure that if you take the Camelback design patent and you compare it to your Contigo bottle, it will be different. There will be differences, several differences. And so and we have, we've reinstated many sellers who copied the general idea, but not the exact same shape. And Amazon somehow removed it, although it wasn't exactly the same, and there were many differences. The real question, is it infringing or not? The test, the legal test, is substantially similar. That's the test. So is it substantially similar? Maybe you think it is, and maybe Francois won't think it is. So it really depends. It's a little subjective. That's why you have, some judges will say this, and maybe an Amazon representative will say no, or the opposite. So it really depends. But when, generally speaking, when I see 5, 6 differences, 7 differences, usually Amazon won't remove it or will reinstate it.
So what do you see the most of with your team? Is it claims for, or removals or restrictions? I forget the word, I'm sorry.
Suspensions.
For suspensions for trademark, for copyright, or for patent. What do you guys get the most of?
I think these days, copyrights. It changed for a while to trademarks. There are always the trademarks complaints for the resellers, right? If you're a reseller on Amazon or on eBay, and you resell Nike shoes, okay, and you got them from the original, from the official distributor of Nike in Ukraine, okay? These are original shoes, 100%, right? It's the original distributor. They are well known. And you buy the shoes and you sell them on Amazon, or you sell them on eBay, and then Nike comes in and files a complaint saying that you're selling an infringing shoe. Now you haven't, but they don't know you. They know the official distributor, and sometimes the brand doesn't check, or sometimes they check but they don't care, and so they're like, sue me. So very often we see IP complaints that should not have been filed. So they file, reselling this shoe is actually, that's not a trademark infringement. It can be many other things, and there are exceptions, but according to the first sale doctrine, it's not infringing. The first sale doctrine, just maybe I'll complete. If Nike sold it once, right? They sold it. This distributor has sold it to me. I paid for it. There was a first sale. So Nike got money for this shoe. Right. So once there's a first sale, I can resell it, and that's not an infringement of trademark. It can be something else. Maybe maybe there's an agreement between the official distributor and I know about it, and I'm intervening in their agreement, or many other things, but it is not a trademark infringement. So that's a false one that we see. I think the second is the copyright, and then maybe the third is design patents and patent infringement.
Gotcha. So I have another question, and this may be a really broad topic that's going to lead us down a rabbit hole, but like
that's my job.
I know. We're switching roles here today. So folks who are selling, and I've wondered this for years, folks who are selling like Disney products. Disney has to have copyrights and trademarks on all of their stuff. There's no way that they don't. But all of these like Mickey and Minnie Mouse t-shirts and I don't know, plates and binkies and everything else that folks are selling, like how does that work? Like with using such a large company's design to sell your product? Like they're not requesting, are they asking for approval from Disney on that kind of thing?
So some of them get the license to use it for specific products. Actually, Disney is a good example because that's what they do. That's actually their model. So you can get a license to sell, for example, bottles in a specific territory in the States. Maybe only online, a specific license to use the brand on specific products. In most cases, those brands are asking for a minimum of sales, like a crazy minimum of sales. So only like a large manufacturers or large companies are able to do that. Usually they choose someone who's already in the business of selling bottles for years, and they're already very established. So most of these companies, the larger ones, it's hard. I mean, many sellers ask me, "Can I sell? Can you speak with Disney on on my behalf?" Usually for sellers, it's just not relevant. But for major companies, and sometimes there are sub licenses. Like you get a license. But to get it, you need to have, 200K of sales per month or something, or 400K or $1 million. And so you split it with others. There's a minimum. So you have to pay them their license fee, right? Maybe 100K per month, you have to pay them as a license fee. So sometimes you split it, you do a sub-license. So that's the way it works.
Gotcha.
And sometimes it's what you see is just infringing.
Yeah, well, because I've got to believe like all of these, and to each their own, but all these like small Etsy shops with, folks at home creating designs with a Cricut, and they'll make like a little Disney t-shirts for the family going on a trip. Everybody wants a cutesy little matchy match like that.
Yeah. They are often infringing. They are often infringing indeed. On Etsy, I've seen thousands of. Can you hear me? Because you kind of froze.
Yeah, okay. We all froze up on my side.
Okay. Maybe I should talk about Frozen for a while. But
we certainly can.
Yeah. So talking about Frozen, I mean, I'm sure you can find on Etsy. I've had many cases where we help sellers who are doing kind of derivative works. Like what they were doing is jewelries of like Superman or jewelries of Frozen or whatever. And they didn't realize that these are icon, or, these are like the S of the Superman is actually protected. So they used it and they thought if it's their design and they design something, then it's okay. But then they get suspended. But Etsy, I think, is much easier than Amazon when it comes to those infringements. I mean, they'll tell you, and if you remove it, you'll be fine. You'll be really suspended if you have a lot of those.
Gotcha. All right, good.
And so I also have a question in regards to patents, because a lot of what you're saying is really the protection, but protection is not free. Right. Mm-hmm. No matter what, how much you wanted to spend on a utility patent or a design patent. From my interpretation, please tell me if I'm completely ignorant to this, but my interpretation of it is that you spend the money on the patent only to be able to protect the patent. Now, it's sort of to prevent others from copying your idea and saying that you own that patent on it, but it doesn't mean anything. The police won't go after someone and arrest them for infringing on your patent. It's something where you have to take it, outside, and you have to pay for, an attorney to sue them. Right.
So not necessarily.
No. Okay.
So the cool thing about about the new laws, there's the DMCA that we've discussed this morning. The DMCA laws actually kind of force the platforms to take action if somebody files a complaint. So just to give you an example, if I have a trademark And I registered the name Cabilly in relation to my bottle here. Now you used it, and you started using the name Cabilly on another bottle or something else related. I can file a complaint on Amazon, file using the form they have online, either on the brand registry or the online form that they have. It will take me 3-4 minutes, just like I explained earlier, and then Amazon will remove it, and you paid zero. You did it yourself. Some of the companies have students doing that, like monitoring infringement and filing complaints. In some cases, it becomes harder. That's why I said about, like, for utility patents, while design patents, for example, Amazon understands, a design patent at the end, these are images. I mean, you see the images of the camelback, you see your Contigo, and then they compare it, right? But with utility patents, I don't know if you've seen a utility patent, but it's super complicated. Like the layman, I mean, most people cannot understand it. It's like a claim, super complicated. So Amazon doesn't want to get into that. For years, they did not enforce it. So you fought for 3 years with the USPTO, you paid thousands of dollars and you got your patent, and then you file a complaint, and Amazon tells you, oh, thank you, Francois, for filing the complaint. We have informed the seller that you have filed the complaint, and please take it with him, and good luck. So that's basically what they used to do. And then about a year ago, maybe more, 2 years ago, I don't know, I lost track of time, Amazon started the patent evaluation process. Have you heard of it?
I have not.
So that's a cool thing that Amazon started. It's a kind of arbitration in relation to patents. So you're the patent owner, you file the patent evaluation process, and then you mention specific listings. You mention Lisa, you think she's infringing, and you mention mine, you think I'm infringing. Okay, so you filed against both of us. We get the notice, and it says, yeah, you received an infringement notice about patents. If you want to fight this, please lodge $4,000, and then Amazon will appoint an arbitrator. If I don't do that, I just lose, and the listing is closed. If I put the money, then you have to put the money as well. You as the filer, you file, you have to put the $4,000 as well. My 4,000 and your 4,000 are kept there during this process, and whoever loses the 4,000 as well, and pays Amazon. So basically, the arbitrator goes into the details. They look at my arguments, they look at your arguments, and at the end of the process, they decide who's right. If I was actually infringing, then I'll be removed and I lose the 4,000. You get your 4,000 back, and I'm out of Amazon. If it turns out I was right, you lose your $4,000, and I'm still here on Amazon with my listing. Same for Lisa.
And how specific is that? How specific do they have to be saying, for example, in the camelback example, do they have to say, hey, this piece right here, or I guess how specific do they have to get to say that you are infringing on our patent?
They have to be very specific. I mean, they have to show, so the patent has claims, they have to show that it's infringing the claim. And if it doesn't, if there's even one small part of the claim that I'm not infringing, I'll show it and you lost the case. That's how it works with patents. You have to be infringing the entire thing. Otherwise, it's not infringing. So when you file it, you have to explain, which claim the infringer is infringing, and you explain exactly how. And then I have to file. It actually looks like a kind of lawsuits, technically, but it's very short. It's like 2 months, and it's basically done. So I think it's kind of fair. It's a little in favor of the patent owners, because if I don't have $4,000 and you filed it against me, even if I'm right, I still have to fight. And if I don't have $4,000, I just lose, and my listing is suspended.
But that has to do with the owner also having the funds to fight every case, like fidget spinners or pop sockets, right? Or I think pop sockets was a better example where they were suing everyone. And I think it turned out where they didn't actually own the patent and it was actually someone else's idea or design. But it all comes down to, do you have the capital to, pursue this? Is that right?
Yes. So that's why I said, I mean, I think that the bottom line is that there's a difference between between the IP. So if it's trademark, you can file it yourself using the complaint, and it's super easy. Just file a complaint, remove it. File a complaint, remove it. If it's a copyright, same thing. If it's a design patent, same thing. With utility patent, it's more complicated. You need your lawyer, basically. So it does. That's why I'm saying I think that most sellers just don't get into this game. They say, okay, if I design something, I'll have my design patent, and that has its own value, and that's it. I mean, I'll end it here. Again, unless you invented the moon or the wheel, but in most cases, most Amazon sellers just won't do it because they, just like you said, they don't have the fund. Just getting a patent is 10, 15K. Many sellers don't have it.
And that's just for the US, right? Or is that a global?
One.
That's just for the US.
It's just one.
Yeah.
So how does that work? If we're saying that trademarks and copyrights tend to be a little bit simpler than patents, or at least that was my takeaway from a lot of this conversation, do those also apply on just the US basis, or does that cover them in Canada, for example, or anywhere else that they're selling?
So if let's discuss trademarks, for example. Trademarks is per territory. So if you filed in the US, you're protected in the US. If you filed it's just me now. If you filed it, I feel alone. If you filed it in Canada, you're protected in Canada. By the way, Canada is one of the most expensive countries there is for trademarks, and I have no idea why, but it's just expensive. Their trademark office charges a lot. Their local lawyers charge a lot, so it costs like twice a US trademark. But every trademark is different. Every territory is by its own. But for Europe, you have one registration for all 27 countries. UK was one of them, but then they're out. So now it's everything except for the UK, where you have to file separately. So that's for trademarks. For copyrights, you have, as we said earlier, you don't even need a registration, right? I mean, you're protected from the moment you created it. You can enforce it without a registration. The only exception is in the US, if you want to file a lawsuit, really a real lawsuit with the court, then in that case you need a registration with the Copyright Office. But other than that, just to enforce it on Amazon, on eBay, on Etsy, all you need is to present just evidence that you had it, just like I said earlier, like a link to your work or something like that.
How much is that copyright?
Sorry?
Registration. How much is that copyright registration?
If you do it yourself, and some of our clients, sit and learn with YouTube's how to do it, it's about $50, just nothing. Yeah. It's not a lot of work. It's basically, sorry.
Oh no, I'm sorry. If I'm cutting you off, please just tell me to shut up. I was going to ask, when it comes to copyrights, would you suggest they file the registration in the event that someone does go with, let's say, making that second website and saying, well, hey, they're just stealing it from our second website? Would that protect them even further?
I mean, you can protect everything. I think that Amazon sellers have tons of expenses, and you have to decide what you're doing first. So a trademark is a must. You cannot be a private label without a trademark, period. It's just hell without it. Anybody can jump on your listing. Anybody can use it. So trademark is a must. Now, for copyrights, I've seen sellers filing their photos, so that if somebody copies it, they can file a complaint. But then, you can file it without it. So it's true that, there are extreme cases where somebody claims and put their website, but then what we do is we show, hey, look at that website, look at when it was applied for, look at the registration date of the domain name, and then we just prove to Amazon that we were there before. So would I go and file for every copyright I had, for every photo and every text I have? No. I would file copyrights for specific graphic designs. That I would do, because that adds value to the company, that adds in the exits, buyers love it. So graphic design, if you have special designs on, I don't know, a special pattern that you invented. Stickers, right? Stickers, or a pattern on your rug, or even on that bottle that you have here. So if you have a particular design, then that's a good thing to copyright. Other than that, I wouldn't copyright every image my photographer has invented. I don't see the point.
So how does it work when, like, let's say that you start a private label and you commission the logo for your private label through like Fiverr or something like that, and your brand gets super big. Well, one, through Fiverr, is there any kind of like implicit ownership of that IP, or does the Fiverr artist still own it? And can they come back and be like, this brand is huge now, I made that logo, I deserve X percentage of the profits? Like, is there any recourse for that?
So it's a good question. Actually, Fiverr has it. I like when clients use Fiverr, because Fiverr actually takes care of it, most of the contracts. So there is actually a contract that says that you get the copyrights in most cases.
Okay.
But so that's usually not an issue. You don't see it as an issue when somebody actually designed your logo. But we've seen cases where a photographer took photos for you. Let's say, I don't know, you had an event, or you had you just had your photo shoot, for your products, right? And now the photographer gave you the license to use those on your website and maybe on your company, I don't know, inserts. Okay. Now, tomorrow you want to use it in a commercial on TV. You did not get a license for that. And the specific photographer did not transfer the copyrights to you, so he still owns the copyrights. And that can be a problem. That's why when you hire a photographer, make sure that you have a contract. It doesn't need to be a 10-page contract. And for me, even an email saying I transfer the copyrights to you, that's enough as as a proof that he or she transferred the copyrights to you. But very important to get those copyrights, because they could potentially claim and do some noise around that. It's very rare. It doesn't happen that often. Most photographers are, they want a good career. They don't want people to complain about them. So it doesn't happen that much, but it could.
It could happen. Interesting. I have to make a note of that for a personal project.
and talking about emails, so I remember back in middle school, they used to have us email everything back to ourselves and say, well, if anyone were to steal your idea in the future, you have it written down. And we're middle schoolers. It didn't really matter. But is that a solid foundation to sort of say, hey, I own these designs? Like, would that be able to hold up in court or with Amazon?
Yes. Amazon, as I said earlier, they're not really looking for solid proof, but there are lawsuits where there are cases that people, instead of going, the whole idea of a registration with the Copyrights Office is basically to say that's mine and there's a proof, there's the government. All they're saying is that it was actually filed. That's it. So it's a proof. So sending it to yourself, you wrote a book, you want proof that it was yours and it was written on April 5th, then send it to yourself. That's a good proof. And that's what, by the way, in many countries, there is no registration. There's just no system for registration. So that's exactly what people do. They send it by email. They send it by regular mail with an envelope that's sealed with the with the date, like in the old days. So that's what they're doing, and it's a good proof, actually, 100%.
Well, with all the things that folks can change, like with Photoshop and whatnot, I'd almost think that the like sealed, handwritten,
is the best.
Physical mailed option would be better. Yeah, it almost makes more sense.
Unless you fake the seal.
That's true.
I'll send my son to the mailbox.
Yeah,
they love it, right?
So when it comes to copyright, I know Amazon has brand registry or copyright trademark. When it comes to trademark, Amazon has brand registry, or you can file, through a different trademark attorney. Is that the right language? Okay, so you can file through your own trademark attorney. But so what I've seen is that the brand registry costs a little bit more than you could find someone on, let's say, Fiverr or Upwork to file a trademark for you. What are the benefits, I would say, to using brand registry versus your own attorney? Or they didn't call them attorneys; they called them something else. But they said it was very, very inexpensive.
It's you're talking about the accelerator. So I'll explain.
Okay.
Until a year ago, you could file a trademark in any way you wanted, either yourself or through any attorney, and just file it with the USPTO and then show it to Amazon, and Amazon gives you the brand registry. The brand registry allows you to have the enhanced content, the A+ content, a nice page, and it allows you to enforce your trademark and several things that are good on Amazon. So that was the process. Then about a year ago, the USPTO said if you're a foreign company, then you cannot file it on your own. You need a U.S. attorney. Okay, so you could use any U.S. attorney. And then about, I don't remember, maybe a year ago as well, Amazon said, you know what? Instead of using any attorney, there's a list of attorneys that we have here, about 10 law firms. If you use them, you'll get the brand registry not at the end of the registration of your trademark, which is about 8 months. That was the case before. But from the moment you filed it, you get the brand registry. So if you file for those firms that we tell you, then you get the brand registry within like 14 days, instead of waiting 8 months to get that certificate that this trademark is yours. So they started doing that. And I think that, I don't know what happened, but about a month ago, Amazon just changed the rules, and they went back to any lawyer that you want. You can use any lawyer to file your trademark, and we will give you the brand registry if you just file it. So not only those specific firms that we've approved, but any firm whatsoever. So the price, that it was good for the prices. Some of the prices went down, and so most of the sellers are happy about that. So you can file it in any way. If you're a U.S. person or a company, you can file it yourself. It's not very much recommended to do it yourself, because you have about 50% chance to get that trademark at the end. Most sellers have. Some of them are lucky, but some of them don't do a search as they should, and then they're missing some of the trademarks and just losing money, and especially time, because they didn't do it the right way. So very important when filing a trademark. We at the firm were, I won't say I'm obsessed about our success rate. So we include in the cost a mandatory search. And we will not file a trademark that will not pass, period.
Is that a discovery? Is that the discovery period?
There's no discovery on trademarks.
No discovery?
No. So before you file the trademark, you conduct a search on the database, and you look what's there. If you're filing the brand, let's say Copco, you're filing the brand Copco for bowls. And then you do a search, and if you do the search, Francois, you'll search for Copco and you'll see there's nothing, so you'll continue. If I do the search, I'll search for Copco, but I'll also search for anything starting with Cop C and then I'll find out if there's Copca. And Copca for bubbles is too close to Copco, so it will not pass if you found it. That's why it's important to do a professional search. Again, there's no extra cost in most cases. So if you do this search properly, you will not miss that Copca that can block you. If I do the search and I see there's a problem, I'll tell you, listen, you have 30% chances to get that trademark. Let's not file it. Choose another name. And that's why one of my most important mission for 2021 is to convince sellers to do the search before they manufacture, before they chose the name, before it's on the listing. Because once they decided and they manufactured, they cannot change the listing there. They cannot change it. Amazon doesn't allow it. So you launch it, you spend tons of money on production, you spend tons of money on your listing and getting reviews, right? And then you have sales, and then turns out you cannot register this trademark because it's taken, there's something similar. You cannot change it at that point. So that's why I'm saying, just remember before you choose the name to do a proper search, and to do it right. And when I speak about, I speak a lot about exits because of my, the second company I co-founded, and buyers, buyers who buy those brands, they will not buy a brand that doesn't have a trademark, period. You cannot, you must have, as a private label, you must have a trademark. It's a big issue having a trademark problem and not having that registration. For the buyers, it's a big problem.
Is there a certain multiplier that buyers attribute to the amount of IP that you own, whether that's copyright or the various trademarks or anything like that?
It's a good question. There's no, you can't put a number on it. Just, multiples in general are they vary, they change the more we advance in 2021, they go up. I think that in every deal that we're doing at Fortunet, we're kind of beating our own record and beating the general multiples in the industry. What you see generally is that two things happen when you have an IP. And when I'm saying IP, again, either a trademark is a must, but having a design patent, for example, or having copyrights, this is something, we at Fortunet, we see the difference. When we come up with a business that has design patents, they are just way more interested buyers because it's unique and buyers are looking for unique businesses. It's protectable and enforceable, so you can remove anybody who has, copied your design. And again, the multiples are just higher. So is it 0.5 more? I don't know. Is it, will you get $500,000 at the end more because you have a design patent? Sometimes, yes. That's why I'm telling clients it's $2,500 maybe this design patents, more or less, maybe $3,000 depending who you work with. But then at the exit, it could be $100,000 or $200,000 or maybe $1 million. So if you have something to protect it. I think it's worth it. Maybe not on the first day, but you have a year to protect it from the moment you published your design patents. Just remember it, and if it's a good product and it sells very well, invest in it. When you sell your brand, it will come back to you times thousands of dollars.
No, that's great.
That's a great piece of advice, definitely.
When it comes to design patents, you mentioned something about a year. Is there a certain amount of time that they just last, or is that first year just other people can file to combat that one?
So the general rule is that you cannot get a patent or a design patent for something that's already out there. Okay, I cannot file, this bottle that has been sold for 5 years. I can't just appropriate something that's not mine. And the USPTO, I mean, nobody will give you monopoly over something that's already there. What they'll give you is monopoly over something that you're disclosing to the public for the first time. You will get monopoly for 14 years or 20 years or 25 years, depending on the type of IP that you have or and of the country. But you'll get maybe 14 years of protection for these particular design patents, and then it's public domain, right? So there's an exchange. I mean, you protected it, you showed it to everybody, and after 14 years, then it's public domain and anybody can use it. You gave it to the public. That's the kind of give and take. So the idea is that you're only protected for something that was never published anywhere. The exception is the US and Europe, where you have 1 year of grace period. If you invented this particular design, they will give you 1 year to see if it sells, it's going well, and then you can file it. So you didn't kill your own patent. In other countries, if you want to protect it in China, you must do it before it's published. Otherwise, you killed your own protection. That's why people are keeping the patents very secret and they don't tell anybody because they want to protect it.
Mm-hmm.
Should a seller, so 2 parts of the question. One is, how does a seller find out if a product is already patented? And the second is, if they wanted to go with a new design, how do they protect themselves from foreign manufacturers taking their idea?
So how do they protect from foreign manufacturers? I mean, by filing, if you filed it in the US and you filed it in China and you protected this particular design, you're protected in usually you also do Europe. There's one registration for all the countries. If you did all 3, then you cover China, where a lot of the manufacturing is happening, and you cover the US, where they cannot sell because it's protected, and in Europe, then you kind of covered everything. The first question you ask is more complicated. How do you know if it was already patented? So you want to know if it's patented if you copied someone else and you didn't design it, right? I mean, if I'm a private label, 95% of the private labels, they're looking for a product that's already selling, right? And then they find a supplier that's already doing it, and everything already exists. So basically what they're doing is they're copying something that exists and they're trying to improve it. If they improve it a lot by doing changes in the shape of the product, and so they may be okay. Maybe there is a design patent, but they're not infringing because there are enough differences. If they haven't done that and they're just copying the design as it is, then they may want to do a patent search to make sure it's not protected. The best way to do it is to hire a patent attorney that will do the search for you. It's not all the sellers will do it. Some of them will hire someone from Fiverr. I prefer that they do that instead of as opposed to not doing anything. I prefer someone from Fiverr. And the third option is to maybe start with your own research. And I always say that when clients are suspended, they become the best searchers in the world. I mean, they within a second they tell me that's the patent. Here it is. I know what I infringed, and I'm like, how did you find it? So there's a nice database called Google Patent, and it's a database that Google made. That includes all the patents. So if I copied the camelback design, right? I mean, I want to manufacture a bottle that has exactly the same shape as the camelback design. So what I'll do, I'll go on Google Patent, and I'll type camelback, and I'll see all the patents and design patents that they have, and I'll look for the one that I want to protect. If it's there, then I cannot use it, but then I can maybe change it, make enough changes to kind of create something else. you have to make sure that you're not creating something that's substantially similar, right? As we
So you
said.
can't just add an inch to each side and then
No.
say that's your okay.
It's substantially similar.
Okay.
That's for sure substantially similar. The question is, what if I take the exact design, but I add, I don't know, something at the bottom and something on the top? And so sometimes you take the thing and you just add things. That can also be infringing because the entire design is there. You just add it to it. If you want to change it, you have to remove some of the things and change them with something else.
So that's why less is more.
Less is more.
Less is more.
Ooh, good student.
Yeah, already taking something away from this. No, I mean, this is quite honestly, this is a conversation that I do have with a lot of sellers and both that are very new and very established. And it's their biggest fear when they find a product and they don't know, hey, is this a patented product? And I'm like, man, I can't tell you, honestly. I don't know. I've seen 10 other requests for very similar products. So I can't tell you that it is patented or it isn't patented, but I would suggest just Googling it. And now that I did not, I didn't know about Google Patent.
It's a good advice. It's a good advice because on Google as well. I mean, that's the second advice. The first would be focus on the company and search it on Google Patent, but also do Google search. Start with that because Camelback, if you go on the website, I'm pretty sure that I write about their patents. Many of them are, they're showing the numbers of the patent even. So start by Google. I always say ask your supplier as well. I mean, they're smart that they're asking you because sometimes, it's actually interesting to see it. A lot of the factories, they know that there's a patent because their sellers told them that there's a problem. So they know that there's a patent. So you're about to buy it, and then you ask, by the way, is there a patent? They're like, yeah. they wouldn't tell you. Yeah, they wouldn't tell you in advance, but if you ask, they'll tell you.
Well, so it's not on the manufacturer though. In regards to if you're purchasing it from them, they wouldn't get in trouble for producing the product because you're the one that's importing it.
Right. I mean, if the patent is in the US, they don't care. I mean, it's not, they'll sell it. But if you ask, did you ever have a client that had a problem? And I say, yeah. So we had one client who had an issue with that, but there's this company, and they are very knowledgeable. In many cases, they really help their clients, so they know exactly what's happening. If you have a problem, ask your supplier, did anybody else have a problem? What did they do? It really helps. We get tons of good information from the suppliers. That's why everybody asks you.
That's why you get all the questions.
I do get the question. Yeah, no, I'm sure. And it's unfortunate that I can't always say yes or no to the patent question. But a lot of times I think it comes with the fact that, hey, I've seen it all over Alibaba. And they might say, I see 10 or 15 suppliers that are able to produce this. Why can't you find a factory that can make this for us? We're like, well, those are, first of all, 10 out of the 15 are trade agents that are just buying it from manufacturers. And the other 5 are much smaller factories that probably don't even know that there is a patent on that product. Yeah. So it's hard to explain that. But knowing now that really companies can be using this less is more model and that you could tweak it by removing certain pieces, I think that is a good piece of advice that I'm able to also share now. So I do sincerely appreciate that.
Change a lot. What's interesting and maybe that's something to take on. If you change it enough, not just remove one piece, but really kind of take the idea but redesign it, then you'll not only you won't be infringing, but you'll have your own design. So tons of sellers that we have been having problems. They were infringing, and then they become the patent owner or the trademark owner.
Yeah, you had talked about that in your Branded by Women session. Yeah, and I was like, oh, that's interesting.
Yeah, a lot of them had problems, and then they become the owners, and then they remove people. So it's like their own payback.
Oh gosh. Well, we'll have to have you on again to hear some of the stories of having folks turn from the one that was exactly. But it's insane. We've already been talking for an hour. So just to go ahead and wrap things up. Again, we'll have to have you on again, Yael. Thank you so much.
Sure.
Go on ahead and let's just take a couple minutes. Why don't you plug? We've kind of talked all about what Cabilly and Co. does, but if you want to give a quick bio of the company, and then also a little bit about Fortunet and where folks can find you if you have any questions, or if they have any questions, I'm sorry. But yeah.
I have questions. So at the firm, as I said, we do anything related to suspensions and intellectual property. So if it's trademark registration, if it's copyrights, patent, planning the strategy, that's exactly what we do specifically for e-commerce sellers. We also do any contracts related to e-commerce. In general, we do not do anything else. We don't do family law or real estate. We just do e-commerce and IP. So the second company I co-founded with two partners in 2018 is Fortunet. And this is where we help sellers selling the business. So the idea of the company is we're on the sell side only. We have one goal, which is to maximize the value of the exit. And it kind of goes well with the IP part, but really the mission of Fortunet is you have one exit, or maybe you'll have more. But right now it's a lifetime event. And for medium and large businesses, you can really maximize it. And sometimes we see sellers just leaving hundreds of thousands of dollars on the table because they didn't know that they could adjust. They didn't know that how to create the P&L. They didn't know that you could add back some of the expenses and your profit is higher, so your exit is higher. So we work a lot on those financial part and negotiating the financial part. We work a lot on the presentation of the business, the storytelling, and then on the auction. My colleague Jake will be here soon to discuss the details of that. So I'll let him
talk more about that. And we're very excited to have Jake on. We're looking forward to that. Well, thank you so much. If folks have questions, how's the best way to get a hold of you? Just through a contact form on either of your sites or LinkedIn or?
Yeah, or Facebook or LinkedIn. I'm available. Best way is the website.
Okay, perfect. So we're going to link both of those in the description of the YouTube and in the audio version. Cabilly and Co. can be found at e-cabilly.com, Fortunet at fortunet.net. And then as always, Yael, thank you so much again. This was such a fun conversation. That hour flew by. I feel like they always do.
They do. And we're going to have to stay connected after this. I would love to utilize Cabilly and Co. as a resource for a lot of the e-commerce sellers that we work with.
You're going to get so many folks sent over from Francois from now on.
Well, like you said, I didn't even realize there's a lot of money that's being left on the table, I'm sure, from what they could, protect their IP with. So I do appreciate it, Yael.
Thank you. Thanks very much. It was fun. We'll be in touch.
Awesome. Thank you everybody so much again for watching and for listening. And we'll see you guys later this week, tomorrow, actually, I believe.
Yeah, tomorrow.
All right.
Bye, guys.
Awesome. Thank you guys.
Bye-bye.
Bye.